The ATF and the Biden Harris administration wants to disarm all of us. We're going to have to get a little geeky because I'm going to show you one of their strategies for doing so that I think has flown under the radar. Specifically, I'm going to explain how the legal theories they are advancing before the United States Supreme Court in the Vanderstok case dealing with quote-unquote ghost guns, which are unserialized firearms and gun parts, how the ATF's position with the Biden-Harris administration's arguments are exactly that. They're setting the precedent for declaring that AR-15s are machine guns and can be banned because they cannot be added to the NFA register. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarm: What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. Check it out, and if you haven't put a review on Amazon, feel free to do so. Good, bad, or ugly. I always enjoy reading those. Okay, folks. We're going to have to get very geeky and very detailed over the next month or two dealing with this U.S. Supreme Court case of Vanderstok, which is supposedly the ATF Biden-Harris administration's policy or attempt to try to regulate so-called ghost guns, which is a political propaganda term for unserialized weapons. Now, we're going to really get geeky on a lot of this stuff, but I want to put this into a big picture framework because this is a complicated case. We're going to win this case, by the way. The Second Amendment community, I think, will win this case. We will be fine in this case. With that said, it's extremely nuanced and very difficult to understand parts of this case because of all the moving parts and the legal technicalities. So I'm going to break it down for you so you all can understand it. But today, I want to discuss and start setting up the framework for understanding why this Vanderstok case against Merrick Garland and the ATF is so important. It's because this case is the proverbial camel's nose under the tent. This is an attempt by the ATF and the Biden-Harris administration to set a precedent that they will in turn use, in my view, to convert AR-15s and semi-automatic rifles into definitionally, hear what I just said, definitionally machine guns that can then be banned under the National Firearms Act. Okay? Now, to understand how the ATF DOJ is getting there, it's important to understand a little bit of history here, how the ATF and the Biden-Harris administration is changing all of this so that moving forward they can declare any weapon, anything they want, including they can take a random semi-automatic rifle and make it a machine gun, definitionally in the new world order of the Biden-Harris people and the DOJ anti-gun, the anti-gun run DOJ. Okay, so let me just step back for a moment and explain how we got where we are right now. In the 1930s, Congress passes the National Firearms Act, which regulates machine guns, among other things. Now, if you look at the definition of machine gun, it refers to things that are machine guns, meaning they're automatically fired with a single function of the trigger, and the frames and receivers of those guns. And this is why all the dots will get connected, I promise. And the frames and or receivers of such guns, National Firearms Act. In 1968, Congress passes the Gun Control Act, which deals with all firearms. All firearms. They defined firearms to include basically any weapon that can or is designed to or can be made to fire a bullet, essentially, through the function of an explosion. And the frame or receiver of any such weapon. So do you see the parallel path here a little bit? Both in the National Firearms Act dealing with machine guns and other weapons, and in the 1968 Gun Control Act, they define the weapon, and then they say, or the frame or receiver of such a weapon. So what the ATF is now doing is they're trying to redefine the meaning of frame or receiver, and by redefining what a frame or receiver is, they're exchanging the definition of machine gun and most importantly, what a firearm is. Why would they want to do that? Why do they want to expand the definition of a firearm under the Gun Control Act of 1968, which deals with all firearms, all sorts? Well, we know why. Because they're trying to expand the definition of firearm in such a way to argue that it allows them to declare all firearms NFA items, starting with AR-15s. How did they get there? And this is where we have to get a little geeky, but do not worry. It will be totally understandable after I explain it. You see, in 1968, in the Gun Control Act, again, it says, a firearm is any weapon that fires a round, a bullet, essentially, because of an explosion, or a frame or receiver of any such weapon. The Congress did not define a frame or receiver in the statute. Instead, they let the ATF, back in the Treasury Department, not important, but bottom line, the ATF in 1968 came out with a regulation defining what a frame or receiver was. And it was a perfectly fine definition. Let me read it to you, because it's right down the middle. It's what we would all basically agree to. It specifically says that a frame or receiver is, quote, that part of a firearm which provides housing, home for, the hammer, bolt, or breech block, and firing mechanism, and which is usually threaded at the forward portion to receive the barrel. Okay? Frame or receiver. That's how they defined it. That's how the ATF defined it in 1968 after the enactment of the Gun Control Act. Okay? That all sounds okay so far, doesn't it? Now, here is where the geekiness, the inside baseball is going to come into play, and I'm going to help you out understand how the ATF is trying to be slick here to disarm us. There are three approaches to defining what a frame or receiver is. Yes, there's a definition here, okay, from 1968. But then there's the practicality of how does the ATF define this. Now, I should mention before we get to that what happens is from 1968 through 2022, that's the definition of a frame or receiver. In 2022, they then took that definition and then they kind of expanded it. They tried to capture parts of frames or receivers or partially completed frames or receivers and things like that in 2022. Okay, just be aware of that. But what you really need to know is what I'm about to say, which is the three buckets or three approaches that one, meaning you and I or ATF, could apply to interpreting whether or not a particular item or items is an actual frame or receiver. There is what I call the functional right way of understanding what is a frame or receiver in bucket number one. There is the ATF approach to defining what a frame or receiver is from 1968 through 2022. And then there's the newfangled way from 2022 going forward about how ATF wants to start redefining terms in the Gun Control Act and the NFA to expand the number and thus their power over us as American citizens and their power and authority over guns. Okay? Three things. Functionality, the 1968 through 2022 approach, and the post-2022 approach. What are these? The first category is functionality. It's the right answer, by the way. A frame or receiver is something that actually functions as a frame or receiver, meaning it actually does its job. Because as I've talked about in many law review articles in many contexts over the many years, I've explained that when someone says that something is like a Rembrandt painting, it's like a Picasso painting. It's not a Rembrandt, it's not a Picasso, right? In the same way that someone says it looks like a military weapon, doesn't make it a military weapon. It means it's not a military weapon. So too, in my view, if something is like a frame or receiver, by definition, it's not a frame or receiver. So the right approach, in my view, if you're talking to Socrates and Plato in an honest, perfect world, A framer receiver is something that actually functions, it actually works as a framer receiver. That's the first approach. And in my view, that is the correct approach. The Gun Control Act and the National Firearms Act to say a framer receiver is a firearm. And to me, a framer receiver is something that actually works as a framer receiver. But that gets into category number 2 of my 3 categories, which is the ATF's approach to what a framer receiver is between the year of our Lord 1968 and 2022. And I call this either the looking at the item, the present view of the item, or a retrospective or a backward looking or something like that. I don't know how you want to frame it, but basically it looks at an item, the alleged framer receiver. It looks at it and says, is this a framer receiver, or is it close enough to a framer receiver as of this moment in time to be a framer receiver? That's what the ATF has said, because from 1968 through 2022, the ATF's position in interpreting what a framer receiver is they don't have to show that it functions or that it actually works as a framer receiver. I think that's BS, but that's their position from 1968 through 2022. And at least it's been workable. Why is that? Because to understand if something's a framer receiver, the ATF and you and I look actually at the item. We look at the alleged framer receiver and we say to ourselves, is this just a block of metal, or is this something that is starting to look like and be a framer receiver? Is there some milling associated with it? Has the firing, the cavity where the firing components go into, has that started to be milled out? At least you can kind of see that it's moving toward a framer receiver. But here's the key. You look at the item as it stands right here, right now. You look at it and maybe you ask yourself, what's happened to this item in the past? And then you assess, is this a framer receiver under the Gun Control Act and under the National Firearms Act, okay? You see? So you've got the, does it work? Then you've got the, where does it stand today? Now you need to understand those 2 categories, because when you see what the ATF is doing now, you will immediately understand why what they're doing is extremely dangerous to the American rule of law and to the Second Amendment and to our right to keep and bear arms. Because, so what is this third new approach that the ATF and the Biden Harris administration came up with starting in 2022 through today that is being discussed and argued in the Vanderstok case this 2024-2025 Supreme Court term? It's very pernicious and dangerous. And it was all done with a sleight of hand through regulation. Okay? Here is this third category. It is what I call, and I'm just making these words up. You can change them. Maybe if you have better terms of functionality, the retrospective or backward looking or whatever you want to call it, or what I'm about to say, feel free to suggest it in the comments. Now, this third category is the dangerous one, the most dangerous one. It's what I call the potentiality category, or forward-looking or futuristic. What do I mean by that? Now, what the ATF is doing to define whether or not something is a framer receiver is they don't look at, does it function as a framer receiver, category number 1, or does it look like a framer receiver today based on what's been done to it up to today. The third one is the broadest on purpose by the ATF. They say, we look at the item and then we say, what could that become in the future? Hear what I just said? They look at the item and say, what could that item become in the future based on some non-exclusive random list of 8 criteria that's just kind of made up and could be anything. This is the most dangerous, and this is the weapon they will use to try to ban AR-15s. How so? Think about it just commonsensically. If you see a 10-year-old boy on the playground and you look across, that kid has the potential, right, to be Tom Brady. That kid has the potential to win a gold medal in the Olympics. That kid has the potential to be Albert Einstein. He has the potential to be anything, right? He could be anything. If you're looking down into the kid's future, right? That means that what the ATF is doing now is they're looking at an item and saying, does this have the potential to be manipulated in such a way by milling or drilling or moving or manipulation or conversion or restoration, all these verbs, does it have the potential to become a frame or receiver? If the answer is yes, it does, then the ATF's position is it is a frame or receiver. See the game? Category 1, it functions like a receiver or a frame or receiver. Category number 2, we look at it today objectively. Where does this item stand today? And the third one is we look at it today and then we say what potentially could occur down the road to it. And if it could potentially down the road become a frame or receiver, we think it's a frame or receiver and thus a firearm under the Gun Control Act of 1968. That is a huge, brings a whole host of items into the definition of what is a firearm under the Gun Control Act. And that is the goal. Because remember, the goal here is they want all gun-related parts to be considered a firearm so they can force the people that sell those parts to go out and get FFLs, be licensed FFLs. And that also requires them, when they sell those parts, to run a background check as if those are actual firearms, because they've broadly defining the frame or receiver definition to beyond what is a frame or receiver and into something that has the potential to become a frame or receiver. Now, with that said, why does this allow, in my view, the ATF down the road to declare semi-automatic rifles like AR-15s and AK-47s to be machine guns under the NFA? Remember my example of the kid on the playground who has the potential to become Tom Brady or a gold medal winner, right? Or a physicist or whatever? Think about this for one moment. Once you allow the ATF to have the authority to look ahead, to declare something that it's not yet already, right? It's not yet a frame or receiver, but we're going to say it could become a frame or receiver, and therefore it's a frame or receiver today. Think about an AR-15. An AR-15 semi-automatic rifle has what? It's true, it has the potential to become what? A semi-automatic firearm, semi-automatic rifle has the potential to become a fully automatic weapon. All semi-automatic rifles, I'm not the guy who knows how to do all this stuff. I know a lot of you guys out there are great gunsmiths and armorers and gun experts and enthusiasts. You're much better than I am. I'm not capable of doing this. At least I don't think I am. I certainly don't know what to do. But it's pretty clear that an AR-15 has the potential in the right hands to become a machine gun. So once you create a legal framework for the ATF to be permitted under the law to look at an item, and instead of saying, does it work as a frame or receiver, or where is it today as an object, and now you allow the ATF to now look not only as to what it is today, but then you also allow them the authority to look down the chessboard into the future as to what this thing could theoretically become. You now allow them the authority. You've now set the legal precedent to allow them to say an AR-15 today has the potential to become a machine gun through this added manipulation, these changes, and therefore this AR-15 is a machine gun and needs to be regulated. Now you may say to me, Mark, you're crazy. That's absurd. That could never happen. Well, how many of you are tracking some of the lawsuits going on in Chicago involving Glock? Well, those lawsuits involving Glock, as I understand it, you'll correct me if I'm wrong here, those lawsuits involving Glock in Chicago are essentially an argument that says that a Glock pistol, when you combine it with a so-called Glock switch, converts a Glock into a machine gun. And the argument is, as I understand it, that Glock designs their Glock handguns, their Glock pistols in such a way that makes it easy for these Glock switches to be installed in them and to allow these gangbangers to use these Glocks as machine guns illegally, and somehow this is Glock's fault, which of course is an absurd legal theory if you're objectively honest about it. But absurd legal theories are something that the left and the progressive judges specialize in. They love that as long as it gets them to the policy outcome that the left wants. And there's no doubt that the left in America wants Americans to be disarmed, because it's a lot easier to bully and to tyrannize an unarmed population than an armed population, which is exactly why our founders guaranteed and codified the pre-existing right to keep and bear arms in our Second Amendment. All right, folks, so I hope you understand. We're going to be doing a lot more discussions of Vanderstok, because to understand the strategy and the legal arguments by the Biden Harris DOJ and the ATF in the Vanderstok case, we're really going to get to see, in my view, where the anti-gunners are trying to take us. And by me identifying today where the anti-gunners are trying to go, it will help you and hopefully me to thwart this kind of, in my view, unconstitutional conduct, this unconstitutional arguments. Nevertheless, we will also track the Vanderstok case because it's important for a whole bunch of other reasons. But for now, the most important thing to understand is the three buckets. Does it work as a frame or receiver? Or where is the item today versus what it could become? As long as you understand those three buckets, that will really help you understand a lot of the attempts by the ATF to redefine things in a way that gives them more power over our right to keep and bear arms, which is exactly where the Biden-Harris administration wants to take us, because they want us disarmed. And the way to disarm us is to have complete power over the guns and take them away from us. That is their plan, if they can get there. I don't think they can, but they're certainly going to try, and we're going to work hard to make sure that our rights are not violated. All right, folks, hope you learned something here today. Make sure you subscribe. I know a lot of people are trying to subscribe and not succeeding, so please subscribe. We're trying to grow the channel. Feel free to follow me on X. I have over 17,000 followers on X. A lot more information out there every day than I can do a single video, but I can do a lot of posts on X. Make sure you follow me at 4boxesdiner on X. And don't forget to take a look at my book on Amazon, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.